enough to get us live, I'd appreciate it.
Loading through now.
Thank you.
We're live, Senator.
Thank you very much, and good morning, everyone. Welcome to the 130th Maine State Legislature. My name is Joe Rafferty, and I am Senator down in District 34, which encompasses Acton, Lebanon, Wells, Kennebunk, Potts Berwick, and North Berwick. Welcome you to our public hearing this morning. We appreciate you welcoming us into your home, and we're doing the same of you. So if we all keep that in mind, I think we'll do fine. This morning we have public hearing relative to 4 bills. In this order, we'll go with LD 575, LD 494, LD 509, and LD 567. That said, as you're aware, we are continuing with an electronic format for the purpose of inviting public comment on this legislation. Just before we get started, I just want to share a little bit of information related to the fact that the meeting is being held and conducted electronically. It's being live streamed. Some of you will be watching it on the YouTube channel. Some of you will be actually live as panelists. That said, in any other situation, if you would be kind enough to keep your microphone muted until you're called upon to talk, it cuts down on any noise and potential feedback that we might have. These meetings are being recorded and available to view on the committee's YouTube page soon after this meeting has concluded. In a moment, I will call upon the committee members to introduce themselves. But before I do that, again, just a reminder to keep your mics muted, please. And those of you on the committee, as well as those of you coming in to speak, please be sure that your name is visible. And as you enter into the meeting, so if you're waiting to speak, the process will be a slight delay. I guess you'll be in cyberspace momentarily, but as you enter, if you'd have your name visible, I'll ask you to introduce yourself, where you're, the community that you live in, as well as any potential organization or group that you are representing. There's a slight delay, but you'll get here. We have very capable clerk and analysts that can help us out along the way. The format, I would say, is becoming a little bit easier for us to use, but if you're here for the first time, it might be confusing, it might be difficult. We'll do the best we can to help you. Be patient, hang in there, and we'll do the best we can to accommodate everyone. At this time, I'd like to ask the members of our committee, if they would be kind enough to introduce themselves. I'm going to start with Representative Sylvester.
Welcome, everybody. My name is Mike Sylvester, representative from District 39, which is the Eastern Peninsula portion of Portland. I'm also the House Chair of this committee. And I live on Peaks Island, which is the home of the 5th Maine Museum, which chronicles everything from the history of the 5th Maine to in the Civil War and World War II. And also during the late 1800s to the 20s, when we were the Coney Island of Maine, we'd see up to 10 to 15,000 people a day come over for opera houses, hotels, and theaters, bowling alleys, the whole 9 yards. It all burned down right before the Depression, and folks moved to cars. And so Peaks Island became what it is today.
Thank you, Representative.
And I'm sorry, I forgot my little cue about, got so lost up in the 5th Maine. I'm going to be the timer today. I'm going to flash when folks are speaking. The sponsors and co-sponsors will have unlimited time to speak, but the other folks who are testifying will have 3 minutes. I will flash the timer at the beginning of your speaking, and then at 30 seconds, put it up again, and then let you know when your time is done.
Thank you very much, Representative Sylvester. Next up is Stacy Guerin, our senator.
Good morning. I am Senator Stacy Guerin, representing Southern Penobscot County, Senate District 10.
Thank you. And Senator Mearmont.
Good morning, everyone. I'm Senator Dave Mearmont, representing Senate District 12. That includes Appleton, Camden, Cree Haven, Cushing, Friendship, Hope, Idaho, Matinicus, Muscle Ridge Islands, North Haven, Owl's Head, Rockland, Rockport, South Thomaston, St. George, Thomaston, Union, Vinyl Haven, and Warren.
Thank you, sir. Representative Bradstreet.
Hi, hello and good morning. I am Representative Dick Bradstreet. I represent the towns of Vassalboro, Windsor, Somerville, and part of Augusta, and that's House District 80.
Thank you. Representative Cuddy.
Good morning. My name is Scott Cuddy. I represent House District 98, which is Winterport, Frankfort, Searsport, and Swanville. And I think Senator Mearmont could have been that guy who read the disclaimer at the bottom of the auto ads back in the 90s, if you remember him. Very, very quick.
Representative Drinkwater.
Thank you, Senator. I'm Representative Gary Drinkwater, representing District 121, the towns of Elton and Argyle, Hudson, Corinth, and my town of Milford.
Thank you. Representative Gear.
Good morning. I'm Representative Tracy Gear, representing District 9, which is Kennebunkport and the coastal parts of Biddeford and Kennebunk.
Thank you. And Representative Morris. I'm not seeing the representative at this time. Representative Pebworth, please.
Thank you, Mr. Chair. Good morning, everyone. I'm Sarah Pebworth. I represent House District 133 in the Blue Hill Peninsula.
Thank you. Representative Prescott.
Well, hi, I'm Dwayne Prescott, House District 17, and that would be Waterboro and part of Lyman.
Thank you, sir. Representative Rader.
Hi, I'm Amy Rader, and I'm a representative for District 125, which is a portion of Bangor.
Thank you. And Representative Warren.
Hello, good morning. I am the Representative Sophia Warren, and I represent my hometown in Scarborough Coastal District 29.
Thank you very much. As mentioned earlier, we have our clerk with us today is Alyssa Thompson. I'm not seeing Steve Langland this morning, but I do see Ms. Reed from OPLA. Thank you very much for your help and presence this morning as we move forward. So folks, again, please keep in mind that we are, we'll be live. This is recorded. And just so that we're conscious of that throughout our meeting. Thank you very much. At this time, I'm going to open the hearing. We first up, as we mentioned earlier, will be LD 575. So the hearing's open. 575 is an act to establish a conditional presumption of compensability for certain employees in case of impairment from hypertension or heart disease. Good morning, Senator Jackson.
Good morning, Senator Rafferty. Good morning, members of the Joint Standing Committee on Labor. Senator Rafferty, Representative Sylvester, members of the Committee on Labor and Housing. My name is Troy Jackson, and I represent the people of Northern Mercer County in Senate District 1. I'm here today to extend my support for LD 575, an act to establish a conditional presumption of compensability for certain employees in cases of impairment from hypertension or heart disease. Many studies have shown a correlation between workplace stress and elevated blood pressure. According to the CDC, such hypertension increases the risk of heart disease, heart attack, and stroke. A number of these studies have specifically documented the fact that correctional officers experience higher levels of stress than most other occupational groups. That is the reason for this bill. It creates a rebuttable presumption that a correctional officer who has successfully passed a physical examination upon entering the profession or while in the profession and later contracts heart disease or hypertension, that the affliction is presumed to be due to employment. This presumption can be rebutted by the action of the employee outside of the workplace. Day in and day out, the men and women who hold these jobs walk in a high security building filled with people who have been incarcerated, mainly due to their lack of self-control, and have the doors locked behind them. Some of the inmates are violent, some are emotionally challenged, and some are mentally unstable. This makes the correction worker's job unpredictable and highly stressful. Additionally, according to the American Journal of Hypertension, these law enforcement professionals often work long shifts, making regular physical activity difficult. This shift work also disrupts normal sleep and dietary patterns. The physical toll, as well as the emotional toll of the job, contributes to the higher blood pressure rates, which may be the reason that the average lifespan of correctional officers is 59 years compared to a national average of 75 years. So please join me in showing your support for our correctional officers. LD 575 gives them a fighting chance when diagnosed with a life-threatening illness. Thank you for your time and consideration. Happy to entertain any questions. I know there's others coming behind me that know this very well, but I'll certainly try and take any questions that you may have for me.
Thank you very much, Senator Jackson. I do see a hand up. Representative Bradstreet, please.
Yes, thank you, Mr. Chair. Good to see you this morning, Senator Jackson.
Same here, Representative.
I believe that hypertension and heart disease are covered under the workers' comp. This is just to change it to a rebuttable presumption. Is that correct?
It is, yeah. Similar to what we have on the books for firefighters. This would be the same for correctional officers.
Okay, good. Thank you.
Yeah.
Thank you, sir. Any other questions of Senator Jackson, please? Seeing none, thank you very much, Senator, for being here. We appreciate it.
Thank you, everyone. Have a great day.
You as well, sir. Next up, do I have, is it James Jerkin speaking, Alyssa?
Yes, Mr. Chairman. Can you hear me?
Yes, sir.
Well, thank you and members of the committee. For the record, I'm Jim Durkin here today on behalf of more than 800 state and county YASME correction officers in Maine to also seek your strong support for LD 575. The legislation would amend the Workers' Comp Act to establish a heart disease and hypertension presumption for these correction officers. And as we just heard, there is precedence for this law. The benefit is currently provided to firefighters in the state, and rightly so. But it's the job of a correction officer that we're here to focus on today, a job widely recognized as one of the most dangerous and stressful occupations in the country. As we just heard, the average life expectancy of these officers is 59, and key contributing factors to this sad statistic include the constant threat of falling victim to inmate violence, working long shifts, including forced overtime within a closed work environment, and being in a state of something called hypervigilance, which is a symptom of post-traumatic stress disorder and results in an individual constantly scanning their environment for threats. And of course, there's the virtually unavoidable social and family conflicts that arise from these officers bringing their work home with them. In other words, it's a job that's constantly on the minds and in the hearts of the people who do it. And some of the more common physical problems resulting from this daily barrage of stress and anxiety include heart disease and hypertension. And look, I could share a number of stories with you, but I know we have very limited time, so I'll share just one. It's a story of a dedicated officer by the name of Phil Newth, who was given more than 2 decades of his life to this job. Phil can't be with us today because he's on the job right now, but I can tell you that he started as an officer in 1997, and 8 years later, at the age of just 32, he suffered his first heart attack. And after dealing with a wide range of problems and struggles to maintain his health over the next 10 years, Phil suffered a second heart attack just a few hours after he received a commendation for his work on drug interdiction. He was transported to Mass General in Boston, where 12 days later he underwent open heart surgery that undoubtedly saved his life. And about 2 months after his surgery, he returned to work at the prison, despite the fact that his doctors told him his job was killing him. Now, why would he do that? The answer is simple. He's got 3 kids and a wife support, and at the time he was in foreclosure proceedings on his home because he'd used up all of his vacation and sick time, including nearly 100 hours donated by his fellow officers. If this law had been in place at the time, Phil would have been entitled to workers' comp benefits. And the fact that he wasn't and still isn't is fundamentally wrong. So I'm here today for people like Phil to ask you to do something that I think we all know in our hearts is the right thing to do, regardless of the potential cost. When an individual agrees to do this job, they do it with the understanding that it will in all likelihood shorten their lives. So the least we can do is provide them and their families with some basic protection as they try to cope with the health problems brought on by this job. And I thank you for your consideration.
Thank you, Mr. Durkin. I see Representative Bradstreet, followed by Representative Drinkwater with a question, please.
I'm sorry, I forgot to take my hand down. I
No
apologize.
problem. That's okay. Representative Drinkwater, please.
Thank you, Mr. Chair, and thank you once again for hearing from you. I've got a report here that says that these type of conditions are already covered under workman's comp, but the burden of proof now would change dramatically to the workman's comp board. Would you care to tell me about, isn't that already covered under workman's comp?
Well, as you mentioned, Representative Drinkwater, what this does, and we believe rightly so, is shift the burden. I'm not an attorney here, and certainly not a workers' comp expert, but the best way I've ever heard this described is we're all familiar with the concept of innocent until proven guilty. What a rebuttable presumption does is it makes the job guilty unless proven otherwise, and I think there's an abundancy of facts and study that prove that this job does cause these type of illnesses and problems. The legislature and the state already acknowledges that by providing it for firefighters.
And if I may, Mr. Chair, ask a quick follow-up.
Yes, sir.
I've asked this question on the other presumptive questions that we've had about cancer and things like that. If we're going to cover this under presumptive law, shouldn't they have a yearly stress test as part of their employment?
Well, Representative, what we can do, and I believe my colleague Jim Mackey is already gathering this information. I can tell you that these individuals go through a very rigorous physical examination before they start the job and a very intense boot camp, for lack of a better term. In other words, sir, nobody is getting on this job with a heart disease problem or a heart problem. It's something that is, developed over time. And certainly there could be other contributing factors, which is why there is the rebuttable presumption. But we believe that, again, the burden based on a wide range and long-term studies that the burden should be on the workers' comp board. And if I could, Mr. Chairman, one thing I neglected to mention in my testimony, I mentioned that Mr. Newth couldn't be here today, but through your very capable and helpful clerk, Alyssa, I did send her 2 audio files yesterday. They're each only 1 minute long, and if the committee has time, I would encourage you to listen to them at your convenience. They're actually old radio spots that we did with Mr. Newth and a few of his other correction officers way back in 2012, and it was to call attention to other issues at the time, but they're very, very helpful right now just to hear him talk about, and this was before he had his second heart attack.
Thank you. Do we have any other questions of Mr. Durkin? Sir, and you say that those audio files are with Alyssa?
That's correct, Mr. Chairman.
I forwarded them to members of the committee.
Thank you, Alyssa.
Those would be good for a work session. Any other questions? Yes, Representative Bradstreet.
Yes, thank you, Mr. Chair. Thank you, Mr. Durkin. Do you have any idea how many people be included in this category throughout the state?
Well, I can tell you that we have all the state offices representative, and we have another 200 or so in Androscoggin, Piscataqua, and Penobscot County. I would imagine that covers most of it. Typically, this bill was filed in the last session, and I believe you will at some point hear from somebody from the state or the workers' comp board that they could perhaps better pinpoint that figure for you, sir.
Very good. Thank you.
Thank you, sir.
Thank you, Representative. Any other questions of Mr. Durkin, please? Sir, thank you very much for your testimony and for being here today. We appreciate it very much. You have a great day.
You as well. My pleasure. Thank you.
Alyssa, I do not see anyone else. So he did mention that Mr. Hughes was not here.
I just promoted Mr. Hughes, but that was our
did.
last proponent, and we have no opponents today.
Thank you. So
I am here.
Mr. Hughes, how are you?
I'm well, thank you, sir. How are you?
Great.
Can you, okay,
You have the floor.
thank you. Good morning, Senator Rafferty, Representative Sylvester, and members of the Labor and Housing Committee. My name is Richard Hughes. I am the General Counsel to the Maine Workers' Compensation Board. I am here this morning to testify neither for nor against LD 575, which is a bill that would add Section 328C to Title 39A. Under this proposed legislation, if a county or state employee whose regular or incidental duties require the care, supervision, or custody of a person confined in a correctional facility, if that person should suffer heart disease or hypertension, a rebuttable presumption of work-related causation would be created as long as proper medical documentation exists. I'm happy to try to answer any questions now. If during the coming weeks you should have questions or need information about LD 575, please forward your inquiry to the Workers' Compensation Board. We will try to locate the information you seek and transmit it to you as quickly as we can.
Thank you very much, sir. And sadly, when I was taking my notes, a lot of hands went up. I'm sorry I didn't confirm the order. So I'm going to go from my left to right. Representative Cuddy, then Representative Bradstreet, Drinkwater, and Gear, please.
Thank you very much, Senator. And thank you, Mr. Hughes, for being here. And my question is fairly technical, I guess. In looking at this bill, it's placed into Chapter 7. And I, for some reason, had it in my head that rebuttable presumption legislation was, or bill, or excuse me, statute was in Chapter 5. Now, I can't find it. So if we pass this, are we putting it in the right place in statute? I guess.
Sure, yes, sir. It would be, it would follow, it would be Chapter 7, and it would be in right after the Section 328. I'm just taking a look at the act right now briefly here, which is a cardiovascular presumption, and then 328A, which is a communicable disease presumption. 328B is a cancer suffered by firefighter presumption. I think if a presumption were to be put in, that would be a logical place for it, I would think. There may be other places too where it might be inserted into the act. If that answers your question.
It does. not being a lawyer, I don't know how important it is that something be in the place one would expect to find it, I guess. And so if that's where you would expect to find it, you would know better than I. So thank you.
Yes, sir.
Thank you, sir. Representative Bradstreet, followed by Representative Drinkwater and Gear, please.
Thank you, Mr. Chair, and thank you, Mr. Hughes, for being here again. During these hearings that are conducted at the Workers' Comp Board, do you often get a lot of conflicting medical opinions on the causation of the situation?
Certainly can. We can. It does happen.
Follow up, Mr. Chair?
Yes, sir.
Yeah, good. Is it a common thing, or is it kind of an unusual thing? You say it happens, but I wonder, like, what you have an idea what percentage of time that might happen?
I don't, but the cases that I've been involved in go to contested hearings, so pretty much all the ones that I know of for me. But I think that there are probably a lot of cases that don't make it to the contested hearing stage where legal representation is required. And in those cases, I assume it's because the medical evidence is pretty straightforward. I really think it will depend on the facts and circumstances. One would have to know how many claims, how many workers' compensation injuries are asserted, and then from those, how many cases have required medical evidence. And I don't have those numbers, and I'm really not sure. I'm not sure how I could find those.
Okay, that would be good. Thank you.
Yes.
Thank you, sir. Representative Drinkwater, please, followed by Representative Gear.
Thank you, and nice to see you, Mr. Hughes.
Sure.
As we've covered all these other changes to workman's comp law about presumptions, my interest is, does this speed up coverage, or does this delay coverage even longer if it wasn't under the guise of presumption? I know every case is different, but the question here is, if we're going to put it under presumption, isn't speed a factor?
Well, it doesn't necessarily speed it up, actually. The presumption kind of is triggered later at the end, at the hearing stage. It's an evidentiary device, and it creates the burden. It shifts the burden to the employer to prove the non-existence of the fact. And I think, as we've talked about briefly, sir, before, it's if the insurance carrier knows there's a presumption and gets a medical report that confirms, say, the pre-existing medical records that show there was no evidence of hypertension at a prior exam, and the insurer knows the presumption will apply, then it's possible the insurer will step up and make a payment. That can't be certain, though. So yeah, I'm not sure if that helps answer the question. And if it doesn't, I apologize, because I would like to answer this.
Well, it doesn't answer the question, but it gives us an idea of how the process works. And I think we, as members of the committee, we need to know how the process works. And obviously, we want everybody covered under workman's comp. And I do have testimony here from Mehmet that says it is covered if you can prove it.
Okay, sure. And yes, it is covered as any physical injury is covered. And the employee would have to come forward and prove by a preponderance of the evidence that it's more likely than not that the condition, in this case, would be hypertension or heart disease, probably was caused by stress on the job or by some cause on the job. So it is covered in that sense. Yes, it is covered as other injuries are covered. It shifts, though, to the employer, basically the burden of coming forward and showing why it wasn't.
Thank you, sir.
Yes.
Representative Gear, followed by Representative Sylvester.
Thank you, Mr. Chair. Mr. Hughes, I'm curious as to whether you have any information on whether this is covered as a presumptive thing when across the country for corrections officers specifically? Is this something that's typically covered as a rebuttable presumption?
I don't have that information at my disposal. I would have to find that.
It would be, I'd be interested to see. Thanks.
Okay, sure.
Thank you very much. Representative Sylvester, please.
Not hearing.
You're muted, sir.
Welcome again, Mr. Hughes. I said so to my room, and my room agreed that we should welcome you. So when Mr. Rohde, Director Rohde, talked to us about the hearing process, and as he's testified in other bills about this process, my understanding is that someone files a claim, it comes to the Workman's Comp Board, they are given an advocate or an attorney or whatever, they file all of their cases. There's an effort to see if both sides will just agree to the facts. If they can't agree to the facts, then they have the right to go to hearing. And at the hearing, both sides provide evidence. And that's sort of the point where the presumption comes in. Because at the hearing, if it's a normal hearing, so I break my leg and I'm saying I did it at work and there's a dispute about that, I'm going to present my evidence that I in fact broke my leg at work, in this case hypertension, contracted hypertension at work. And then the employer and representative, which is mostly the insurance company, is going to present their facts saying that perhaps something else happened, and then there'll be a ruling. And if they just found, if in the ruling that in fact this is a workplace, this is a compensable injury at work, then the employer is then also allowed to appeal that decision. And it would go to a different set of steps, and that's often what prolongs the hearing process. Now, in a presumption, if I win, right? So the worker is ruled to have an injury that happened at work. Is there also an appeal process for the employer? And I went through all of that just to kind of walk through how complicated all of this is, and why the presumption makes it, because at hearing, then the employer would basically go first to prove, and the employee would be able to rebut the rebutted.
Okay. Yes. Basically, yes. That's the way it is. The process starts with the claim being made. It's either paid or not. If it isn't, a notice of controversy is filed by the insurer confirming that there'll be a contest about this. And then it goes to what's called the troubleshooter. It's a very informal stage where the troubleshooter really just makes phone calls to the parties and finds out if there's any way to resolve any issues that are outstanding. And that's not a mandatory outcome. The troubleshooter has no binding authority. From there, if it isn't resolved, it's referred for mediation. And at that point, the claimant is allowed to get a lawyer. It comes to the advocate division typically, and the advocates, the lawyers that are employed by the Workers' Compensation Board, assist the employee at the mediation stage. The mediation stage also is not mandatory, but the parties have to show up and sit down in the same room. Well, not during the pandemic, but at other times they do. And it really gives them a chance to look each other in the eye, so to speak, and understand just what the nature of the dispute is. Where are they not agreeing? Because they can probably agree on a lot of things, but not on certain things. Then if the case is not resolved and the disputes aren't resolved, then the employee's lawyer will file petitions. The petitions take it to the formal litigation stage. It's at that point, up to this point, the presumption does not have any binding effect. It might impact the outcome in that it could influence the insurer maybe to make a voluntary payment. However, medical evidence is generated, and it was mentioned earlier, is there conflicting evidence? Often there is. When it gets to the contested stage, that's typically when you really find the cases where there's conflicting evidence. We would then go to hearing in front of an administrative law judge. Testimony would be given, depending on how complicated the issues are. It could go more. It could simply be one hearing, actually. And medical evidence records are presented. And at that point, it's up to the insurer, when there's a presumption in place, the employer's lawyer then has the burden of coming forward and proving that, say, if this bill were to pass, hypertension or heart disease was not caused by the corrections officer's job. And that has to be proven by a preponderance of the evidence. That is, that it's more likely than not. The judge will then make the decision. And if the either side is aggrieved and feels that there's a reason to appeal that decision, then either side has the right to appeal. Findings of fact are not appealable. So it has to be an issue of law. Then we get into a whole other questions, but that's kind of a snapshot, if you will, of the dispute resolution process from the informal to the formal stage. The presumption comes into play at the formal stage, at the hearing. That's when it actually has the binding effect, and it isn't before that.
Quick follow-up, Mr. Chair.
Thank you. Yes, sir, Representative.
So I trusted my memory on that part. I remember hearing it many times in the various past that almost routinely decisions that go against the employer or go in favor of the worker are appealed as a matter of course. And so, but I cannot remember the numbers. I can't remember, and I don't want to trust my memory on that. So I'm wondering if we can, for the work session, see a chart of various years, number of cases filed, numbers that went to each different piece of the process, and an idea and some idea of average times, if that's available. I remember receiving such a chart, I think maybe in the 128th, I can't remember, but I think that would be very helpful for trying to chart this process as we look at presumptions and try to figure out if there's any effect on the process. Appreciate that.
Sure.
Thank you. Representative Prescott, please.
Well, thank you. So as it is now, if an employee is denied and it goes through the process and it gets to the point where they're getting an advocate, who pays for the advocate?
The Workers' Compensation Board pays for the advocates. The advocates are about a dozen in the state, actually are employed by the Workers' Compensation Board to represent injured workers. I gather it was an alternative to the, say, you might call the Prevail standard, which called for the insurers to pay for the employees' lawyers if they prevailed, so to speak, or retained any benefits under the Act.
All right, I'm just a little bit of clarity. So they're being denied, so the claim is denied by the unemployment board or the insurance company here?
I'm sorry, sir.
Okay, when the claim is denied, that's because they went to the insurance company. And the insurance company is the one denying the claim, so they turn to the unemployment board for support. Is that right?
I'm not sure. I really apologize. The audio on my computer is not coming through at all. I'd like to take another stab at that. If you could ask again.
Yeah, okay. I'm just for clarification, the claim is denied by the insurance company, yes?
Yes.
All right. So it's the unemployment board that's actually providing services to rebut that claim in favor, in support of the employee.
Okay. So the insurance carrier denies the claim, and the Workers' Compensation Board pays the salary for the lawyers who are representing claimants, if that helps.
Yes, thank you.
They also pay for, incidentally, if I could just say, they also pay for the mediator as well, for the mediation service and for the troubleshooting service.
Thank you very much. Representative Warren, please.
Thank you so much. I wanted to ask you about the, I guess maybe if you have a professional view on this, that it would be, in my understanding so far and listening to you, that we assume that I guess the injury in question is legitimate or not. I guess I'm just wondering about that, or concerned around that the situation as we heard it described by the previous speaker was basically a situation where you had someone who maybe for the health of the prison in question, you have someone that's sick but on the job. Do you have any, I'm sure that it's very important to make sure that these claims are legitimate, but do you have a perspective on, I'm sure that part of why you'd want it to be legitimate would be that it is really maybe a serious concern that we want to make sure to remedy, that we're not having people that are sick or injured working.
Whether someone is injured is typically confirmed by the medical records. Normally, if someone comes to the board with medical records that verify that signs and symptoms confirm a diagnosis, that's really what we have to go by.
And it would feel to me that in these types of situations that you would maybe want to, as much as possible, err on the side of caution, because the risk of the employer or just a good running business, that there could be problems in the longer term if we're, I guess, not seeing that, I guess, that liability itself.
I suspect those are the policy questions that you as legislators will wrestle with. Mine is just my job as a representative of parties before litigants before the Workers' Compensation Board has been to go with the evidence that is there and see where it takes us. And the administrative law judges do that; they're used to it. Whether or not an injury is, say, present, is a decision that's made by doctors, and then it's litigated, and the administrative law judges take the evidence and make the decision. But whether workplaces should have, whether this presumption should be in place to make sure that the workplaces are running smoothly is, I think, probably a policy decision for the legislators to wrestle with on this. It's not,
Yeah, no, that's fair. I appreciate it. I guess I'm just trying to understand or process how we consider the risk of someone being, I guess, or presuming that someone's being dishonest versus, I guess, the health and wellness of both individuals and businesses. So, but thank you very much. I appreciate your comments and expertise.
Thank you.
Thank you. Representative Bradstreet, do you have another question?
Yes, thank you, Mr. Chair. I guess perhaps you're the only one from the department who may be here today, but just as a point of clarification, I think you mentioned that the advocates are funded by the Workers' Compensation Board, and the board itself is that completely funded by employers, or is there a sharing of that with employees?
No, sir. It's funded by self-insured employers, and, well, it is funded by employers in Maine.
Okay, thank you.
Any other questions, please, of Mr. Hughes? Seeing none, sir, thank you very much for your time and expertise. We appreciate you being here today and helping us out understand this proposal. Thank you very much.
Thank you. I appreciate it. Have a good day.
You as well, sir. Thanks. See no other questions. Alyssa, anyone else in terms of testimony? I'm not aware that there is, but.
No, that was our last one for 575.
Okay. That being said, I'm going to close the hearing on LD 575. And our next hearing will be relative to LD 494, which is an act to change the compensation structure of the Maine Labor Relations Board and the State Board of Arbitration and Conciliation.
Thank you, Mr. Chair. Are you ready for me to begin?
I am, sir. I just was trying to scramble for my list real quick. I
Oh,
knew
no
you were
worries.
coming. All right. So first up will be Representative Sylvester speaking for. Go ahead, sir. The floor is yours.
Thank you. Senator Rafferty and esteemed colleagues of the Labor and Housing Committee, I'm Representative Mike Sylvester. I represent District 39, a portion of Portland. I'm here today to present LD 494, an act to change the compensation structure of the Maine Labor Relations Board and the State Board of Arbitration and Conciliation. The first thing that you need to know about the State Board of Arbitration and Conciliation is that it has 3 members: an employee member, a worker member, or a labor member, and for lack of a better term, a neutral member there to represent the public. The second thing is that this board meets in order to adjudicate matters that are brought before it either by public sector labor organizations or by public sector employers. An example of this might be a dispute, contract dispute that's brought to arbitration. Now, the first thing to know about the Maine Labor Relations Board is that it has 3 members as well, although it has 6 alternates, with the 9 members and alternates split up into the same 3 categories of employer, labor, and public interest. The board's 3 goals, oversimplify, are to rule over how collective bargaining units are created, to make sure neither the employer or the union aren't doing things they shouldn't be doing, and to solve problems when the 2 sides can't agree. The fancy words for these are representation cases, prohibited practice cases, and dispute resolution cases. Now, the folks who serve on these boards get compensated for their time, and that's what LD 494 does. This bill adjusts the compensation structure for members of the State Board of Arbitration and Conciliation and the Maine Labor Relations Board. For the State Board of Arbitration and Conciliation, the bill changes the per diem compensation for members of the board to provide that when members meeting to deliberate or vote with respect to a matter before the board, members receive $150 a day per meeting for their services for the time actually employed in the discharge of their duties. And for all other purposes, members receive $300 a day for the services for their time actually employed in the discharge of their official duties. For the Maine Labor Relations Board, the bill provides the board's executive director, Mr. Daly, who will be here to speak later, the discretion to provide the members per diem compensation and related costs from the board's general fund appropriation, rather than requiring the parties to share the costs. There'll be testimony after me that will get into the details of exactly what the boards do for Mr. Daly. If you want to delve into all that, the current historical compensation structures and the reasons for wanting the limits increased are all things that he'll be able to go into in greater depth. But with that, I'd be happy to answer any questions I can answer or politely defer them to later speakers. And I thank you for your time.
Thank you, Representative Sylvester. Do we have any questions for our colleague? Representative Bradstreet, please.
Yes, thank you, Mr. Chair, and thank you, Representative Sylvester. Do you have any idea what how much money we're talking here? If it would come completely out of the general fund rather than having the participants pay each a share of it? Do you have any historical figures?
So I believe that, yep, I believe that's information Mr. Daly will be able to provide. This is a bill this is a department bill that was brought forward by the Maine Labor Relations Board. And so I'm gonna defer all that reasoning to Mr. Daly.
Very good, thank you.
Thank you.
Any other questions, please, of Representative Sylvester?
And I appreciate it, colleagues. They're yelling at me in another committee about a bill that I didn't even receive an email on. So I will hang, they shifted me back. So I'll hang in as long as I can, but I may have to leave in the middle of this to go testify on my surprise bill.
Thank you, sir. Good luck on that. So next up will be Mr. Daly. Good morning, Mr. Daly.
Good morning, Senator Rafferty. Okay, just making sure everything's all set on my end. Okay.
You should be good to go, sir. You have the floor.
Great, thank you. Senator Rafferty, Representative Sylvester, and members of the Joint Standing Committee on Labor and Housing. My name is Neil Daly, and it is my privilege to serve as the Executive Director of the Maine Labor Relations Board and its affiliate, the State Board of Arbitration and Conciliation. Today, I'm here to request your support for LB 494. This bill presents two changes, both of which should benefit Maine's labor management community. I will address a more substantive change first, that being a proposed increase of per diem compensation for BAC members. As you may be aware, the BAC, a tripartite panel composed of gubernatorial appointees, plays a key role in labor management stability in Maine, primarily by providing conciliation and, if need be, arbitration services for contract grievances. Virtually every collective bargaining agreement includes a grievance process, which serves as the primary means of enforcing the agreement. Arbitration is the final step of the process. While Maine's public sector parties have several options for arbitration services, many have agreed to use the BAC. They do so for several reasons, including the qualifications of the BAC panel members, the availability of a tripartite panel rather than a single arbitrator, and the overall lower cost compared to most private arbitrators, whose fees typically start at $1,000 per day. Currently, BAC panel members are paid $150 a day for their services, a rate which has not increased since 2007. BAC panel members typically spend many hours on a case that goes to hearing. Often, hearings last an entire business day or longer. Likewise, the panel chair is responsible for drafting a quasi-judicial decision, a process which typically takes several working days, although the chair is almost always only billed for one day of drafting work. It's fair to say the BAC members are not in it for the money, and instead their primary focus is to provide a public service to the labor management community. We propose to increase the BAC per diem to $300 per day, except for meetings to deliberate a case, which would remain at $150. While the parties to an arbitration would be responsible for the increased costs, those costs for the tripartite panel's decision would still likely be less than a single private arbitrator's decision. It would also hopefully ensure, to the greatest extent possible, that we have a full panel of qualified members readily available so that the BAC can provide the parties with timely arbitration hearings. As to the second aspect of this bill, the proposed change involves simply providing the MRB the ability to absorb the per diem cost of MRB hearings if our budget permits, rather than requiring the parties to split the costs. The intended goal of this change is to reduce the financial obligation to both the parties seeking to enforce their rights under the state's labor relations laws, as well as those respondent parties who have to participate in board proceedings despite the possibility of having committed no violation of the law. Notably, neither of the above changes will require any additional budget allocation to MLRB. Please consider supporting LD 494. Thank you for this opportunity, and I will try to answer any questions you have.
Thank you, sir. We do have a couple. Representative Drinkwater, please.
Thank you, Mr. Chair. You say that typically the members spend many hours on a case that goes to hearing. Am I to understand that they get paid per hour to do all their studying?
No, they don't. Basically, they're paid a single rate per day. And frankly, to the extent that any of them review exhibits in advance or something to that effect, they don't charge for that. So it's really quite a bit of volunteer work on their end. But more fundamentally, what they do charge for is basically the day that they sit for hearing, which is a single rate for the entire day, the day that they meet as a panel to deliberate a case. And then the chair also bills for a single day of drafting. to produce the actual written decision.
And the length of a day is 8 hours?
It varies, basically depending upon the subject matter at issue in the case. Some may last 2 or 3 hours. Some may last a full 8 hours, if not longer.
And also at the very end, I'm sorry, Mr. Chair, for asking so many questions, but it says that requiring the parties to split the cost. Now, I can tell you from my own experience, having served on a school board, I actually think that's a bad idea, because it'd be so easy for the union to say, well, we're going to file a grievance, which they do like to do, as you probably can attest to.
Yeah, that's more, I guess, a policy consideration for the legislature. But in terms of the splitting of the costs, that originates from how the panels were basically every MLRB related function. To the extent that a party files a claim that's going to be adjudicated, the two parties split the costs, and that's how it's been since it was established, so far as I'm aware.
Thank you, sir.
You're welcome.
Representative Cuddy, then Representative Bradstreet, please, and Representative Gear.
Thank you very much, Senator. Thank you very much for being here today, Mr. Daly. Could you go over again? I didn't think I quite understood it. What would the difference be in the fee structure or the payment structure if we were to pass this bill?
Sure. So for the BAC side of things, and again, this is the tripartite panel, their primary focus is to provide arbitration services for contract grievances. So currently, each panel member is entitled to $150 per day. The change, if passed, would result in each panel member being entitled to $300 per hearing. It would also provide the panel chair $300 for drafting a decision. But then for the meeting where the parties, where the panel members gather to deliberate a case, that would still remain at $150.
Thank you.
Let's see where did I go? Representative Bradstreet, then Representative Gear, and Representative Prescott.
Thank you, Mr. Chair. Thank you, Mr. Daly. The bill, it calls for $150 a day per meeting. Are there ever more than one meeting per day?
No. So the way that we currently schedule things is a meeting, because we don't know how long a hearing will take for a particular case. So we leave the day reserved for a single matter. There is a possibility, I suppose, actually, of if the same parties have multiple cases, we may try to consolidate a hearing to a single day.
And I'm wondering if you could provide any financial information for maybe the year 2019, what the budget was then for our work session, because I don't think 2020 would be an apt comparison year. Is that possible?
Yeah, in terms of the overall number of cases that took place and basically the per diems that were paid.
Certainly, yes.
Sure,
provide that.
That would be, yeah, I could.
I appreciate it. Thank you.
And to your other question about the MLRB side of things, that would be the instance of where I would potentially provide the MLRB per diems from our existing budget. The number of MLRB hearings is typically much fewer than the BAC. So to the extent that we maybe have 3 to 4 hearings a year, and the MLRB per diems, it's about $500 per case in terms of a day of hearing as well as a day of deliberation. So you probably on average be looking at $1,500 to $2,000 per year. That's a relatively rough estimate, but it's in that neighborhood.
Okay, very good.
And again, there wouldn't be any obligation for us to pay the per diems out. So if for whatever reason there were a budget crunch or the funds just weren't available from our existing allocation, then the responsibility would revert back to the parties.
Okay, thank you.
Thank you. Representative Gear.
Thank you, Mr. Chair. Mr. Daly, can you give a sense, it's a lot of detail to digest, and so I'm struggling a little with that.
Mm-hmm.
What is the problem that is being addressed here? Is it primarily one of just kind of adjusting compensation in light of conditions? Is it more about, is there difficulty in recruiting panel members? Like what is at the core of these changes?
It's more the latter, in conjunction with what we're seeing in terms of an overall increase in filings, especially on the BAC side of things. So again, it's a tripartite panel. They're gubernatorial appointees, so we don't have a limitless roster of arbitrators that we can pull from. So it's a bit of a balance in terms of finding people who have experience and expertise, because it's a relatively narrow subject matter. So it is really helpful. You can't just necessarily pick anybody off the street to sit for one of these panels. It's really helpful for the person to have some level of experience in labor relations. And so to the extent that, for example, a chair is also working as a private arbitrator, they may face some level of pressure in terms of how much BAC work they can take on and still meet their anticipated annual income. So where, and without knowing precisely what people are charging, it is fair to say that a private arbitrator charges about $1,000 per day in comparison to BAC level of compensation, which is $150 a day. So if you're also working as a private arbitrator, you may have to kind of limit the number of BAC hearings that you can sit on and still meet your anticipated income level, your ability to earn a living. So that's kind of the push for it, in that we're also seeing, yes, an increase in filings. And so we want to be able to make sure that, number one, we can recruit for the governor to appoint experienced people who are going to be able to provide a certain level of expertise for these hearings, but at the same time also be timely available so that we can schedule hearings as expeditiously as possible for the parties.
Great, thank you.
You're welcome.
Thank you. Representative Prescott, followed by Representative Cuddy, please.
Thank you. Did I hear that we're going to shift the cost from the two parties that are in dispute to the general fund?
For one side of things, for the Maine Labor Relations Board, which again is perhaps 3 to 4 hearings a year, it would potentially come from the MORB's existing budget allocation. So there wouldn't be any new line item to the MORB. It would more just be, if we happen to have surplus funds, we would absorb the per diem costs for the MORB hearing. If we didn't have any surplus funds, then the parties would retain responsibility for those costs.
Chair, can I follow up?
Yes, sir.
Why would we want to accept financial responsibility for something that we have nothing to do with? This is a dispute between two parties. And wouldn't, by taking them out of the loop of financial responsibility, wouldn't that probably increase the amount of cases that they're going to hear if they don't have to pay for it?
I suppose in theory it could increase the number of cases, but I think the fundamental distinction that we're talking about on the BAC side of things, the Board of Arbitration Conciliation, those are dealing with contract grievances. Those are instances where the parties have agreed through the collective bargaining agreement to obtain arbitration services from the BAC. In comparison, the MLRB is responsible for adjudicating alleged violations of the law. And so I think what we're seeking to do is, to the extent that one party is seeking, pursuing its ability to enforce a statutory right or obligation, is to reduce the financial impediment for, again, pursuing simply what the law already provides. And it also holds true for a party that is a respondent to an MLRB proceeding where they may have been accused of violating the law, but they may have violated it, but they may not have. And so again, it potentially reduces the financial obligation to them in terms of responding.
And Chair, just one more, please.
Yes.
In the bill, it talks existing language. It talks about if they don't pay the invoice in 60 days, how's that going to affect? I mean, if we're paying for it out of the general fund, are we going to get that money back because that clause is still in there?
Well, that would come into effect to the extent that for the MLRB side of things, if we did not have available funds and we went ahead and shifted the obligation to the parties to provide the per diems, then yes, that clause would remain in effect. That applies to those instances where we go ahead and the per diem is paid to the board members. The parties are responsible for shifting the costs. We send invoices out, and that specific clause comes into effect if a party doesn't happen to timely respond to the invoice.
All right, thank you.
You're welcome.
Thank you. Representative Cuddy, please.
Thank you very much, Senator. Thank you again, Mr. Daly. You're talking about the board members needing to sort of figure their annual income and make sure that they're going to meet their budget. It hits home. I'm a construction worker, and when I come to serve in the legislature, I take quite a pay cut. So I understand what you're talking about there. My question to you, though, was what is the chance that the board would actually be able to foot this bill? When you're talking about the MLRB, when it says in there when it would not create a financial hardship on the board paying for this, how often do you think you'd actually be able to do this?
It would largely be dependent upon the overall case volume. If for whatever reason we saw a spike in filings as well as a spike in MLRB hearings, I'm not sure that we could absorb $20,000 or $30,000 if there just happened to be a year where there was a huge volume of cases as well as hearings. On the other hand, if it kind of stays consistent with, maybe 10 to 20 complaint filings on the MLRB side of things annually, and out of those, maybe 3 or 4 going to hearing, then my guess would be most instances we'd be able to absorb those costs on an annual basis.
Thank you. Could I have a follow-up, Senator?
Yes, sir.
As I read it, this would give the executive director the ability to, if you had a really excessive year where you had a lot of cases, it seems to me that the executive director would be able to pick and choose which cases the board was going to pay for or not, or do you see it as a blanket, this year we will pay or this year we won't pay for all cases?
I think it would have to, the cutoff would more come during the midst of a year, in the midst of a year versus at the outset of a year, deciding we're going to go ahead and pay for all cases. But I appreciate your point and the concern about, picking and choosing. So yeah, in order to be equitable to the parties coming before us, I think it would, potentially be from this date forward, we're not going to be able to absorb the cost just based on the current case volume. But I don't know that we can necessarily say that at the beginning of the year without knowing what's going to transpire during the year.
Yeah, I actually, just as I sort of listened to myself ask the question, like, how are you going to know? You wouldn't know. So you'd pay as you go along. And then once you realize like, hey, it's going to create a financial hardship, you'd stop paying. So that, yeah, actually it was kind of a ridiculous question, but thank you for
Yeah, no,
really appreciate it.
I think we would want to avoid the situation where, for whatever reason, we permitted one party to not pay and then, build the next case up. So it would more be drawing a line at that point. From then on, parties would be responsible.
Thank you both. Representative Gear.
No, that's just a leftover hand, sorry.
That's okay. Do we have any other questions of Mr. Daly? Seeing none, again, thank you, sir, very much for your being with us, and most importantly, for your expertise and willingness to answer all questions. Thanks very much.
Thank you all. Thank you. Appreciate it.
You have a good day, sir.
Thank you. You too.
Alyssa, I'm not seeing any additional testimony on my end. Do you have anyone that's come in late?
No,
Perhaps?
he was our last one.
Thank you. Then, having heard all the testimony and answered as many questions as arose, I'm going to call the hearing on LD 494 to a close. Thank you so much. And I will open, excuse me, the hearing on LD 509, which is an act to protect teachers from a decrease in retirement benefits arising from COVID-19 pandemic. And with us this morning will be one of my Education Cultural Affairs Committee members, Representative Dodge. Good morning.
Good morning. Thank you, Senator Rafferty. May I begin?
You have the floor, yes.
Thank you so much. Good morning, Senator Rafferty, Representative Sylvester, and esteemed members of the Labor and Housing Committee. My name is Jan Dodge, and I represent House District 97, which comprises Belfast, Northport, and Waldo. I am here to present LD 509, an act to protect teachers from a decrease in retirement benefits arising from the COVID-19 pandemic. Maine teachers and educational personnel are often employed as coaches of sports teams or co- and extracurricular club advisors of student organizations that meet outside the parameters of the hours of a normal school day. For some, this is a way to supplement their teaching income. If you are an educator who is approaching retirement, you are extremely diligent to document these stipends, as they are part of the calculation of your retirement benefit. A retirement benefit is based on your 3 highest years of compensation. The loss of a stipend will reduce your retirement benefit for the remainder of your life, and thus compounds over time. I taught in a small rural school district where my regular teaching salary did not reach $50,000 until the last year of my 31-year teaching career. My co-curricular stipend helped me reach a higher yearly compensation average for my last 3 years of teaching and helped raise my monthly retirement benefit. Some teachers, coaches, and advisors were not paid due to the canceling of many school-based teams and activities during COVID-19. The bill as written does not accomplish the intent to ensure educators are not additionally adversely affected by the elimination of a stipend payment, but deals more with the loss of service credit and repurchasing of time for part-time educators experiencing a stipend loss. Both of these are problems worthy of being addressed. I have worked with the Maine Education Association and the Maine Public Employee Retirement System to craft amendment language. I hope your committee will support this bill and the amendment to keep Maine educators whole in retirement. I would ask you to direct your questions to those who will follow and who have a deeper understanding of the language needed to accomplish the retirement protections intended in LD 509. Thank you, and I will try to answer your questions.
Thank you, Representative Dodge. Do we have any questions of Representative Dodge at this time? I think we're holding off for our experts. Representative Cuddy.
Well, just thank you, Representative Dodge, for bringing the bill forward. And if you would rather that I wait and I ask somebody coming behind you, just let me know. But as I understand the sort of the retirement system, there are the last some number of years, I think it's the last 3 years, sort of define what will become your retirement benefit moving forward. So if you were somebody who is in the position of getting ready to retire soon, and you normally taught, you did, girls soccer, chess club, and then drama, or you had these different co-curricular things you did. This year, many of those may not have existed. So your income for that year would have been lower. And this bill proposes to ensure that just because you happen to be getting ready to retire during the pandemic year, you're not going to face a negative impact on your retirement moving forward. Do I have it generally right?
That is correct, Representative Cuddy. You have it exactly right.
Thank you very much.
You're welcome.
Any other questions of Representative Dodge? Well,
Thank you very much.
Yeah, thank you. You have a good day.
Thank you. You as well.
We do have some testimony coming in. I believe, is Steve Bailey first up, Alyssa?
We have John Kaczynski and then Stephen Bailey.
Okay, I had John as neither for nor against. All right, thank you. Good morning, John.
Good morning, Senator Rafferty, Representative Sylvester, if he's here, other esteemed members of the Labor and Housing Committee. My name is John Kaczynski. I'm here on behalf of the Maine Education Association to testify in support of LD 509, and we appreciate Representative Dodge bringing this bill forward. The MEA represents 24,000 educators in our state, including 5,000 retired educators. I'm just going to read some parts of my testimony here. The COVID-19 pandemic has affected us all in several ways. LD 509 attempts to address one impact on teachers and other educators in the Maine public employees retirement system, the loss of stipended positions due to COVID-19. Many school districts, as you heard today, offer stipends for various co-curricular and extracurricular activity roles in public schools. Not all, but most school districts have a variety of stipended positions such as athletic coaches, department chairs, yearbook advisor, you name it, drama club. These are all leadership roles within our school communities. Last spring, and then again this fall and winter, some of these positions may have been cut or curtailed due to the pandemic. Spring sports were canceled in 2020, as well as the fall and even winter seasons. Some other academic stipends may have been cut or reduced due to the inability to have in-person meetings. While this may seem like a small issue, as Representative Cuddy, I think, was just alluding to, if a teacher or ed tech or other main PERS participant is in their final 3 years of service, the loss of the stipended positions impacts their final 3 years of earnings and therefore could have a long tail. Retirees could see their retirement benefits impacted forever due to the loss of these stipended positions. To be clear, many of these stipends are small, often no more than a few $1,000s, and usually the long hours and additional work far outpaces the amount of the stipend. Many educators step up to serve in these roles because they have a passion. They want to provide a service to the students and the communities. The least we can do is make sure the loss of the stipends due to no fault of their own does not artificially deflate their retirement benefits for the rest of their lives. After discussions with the staff at MEPERS, it has come to our attention the current version of the bill only offers a partial remedy. The bill before you allows Maine PERS participants to buy service credits due to stipends not realized due to COVID-19. This will impact educators who are not full-time employees. Some part-time employees, for example, use stipended positions for the purposes of service credit. This is currently allowable, and the bill before you simply permits the part-time main PERS participants to buy service credit for the stipend and positions that were canceled due to COVID-19. However, the original intention of the bill, in talking with Representative Dodge, was to address the long-term impact I described above, specifically the loss of retirement earnings if the loss of the stipend occurred in the final 3 years of service because of the COVID-19 pandemic. As with my testimony, is a draft amendment we asked the committee to consider. The bill would allow main PERS members to buy back the loss of the stipend and to have this count towards their final years of service. Again, there should be no fiscal impact to the state. As you can see from the language in the amendment, this would not be the first time an adjustment has been made to this section of law to accommodate adversely impacted members in main PERS. Further, we suggest the language of 509 be amended to only include the period until July 1st, 2021. The bill currently has a date of July 1st, 2022. You may think we're being bullish that everything will be back to normal in schools by July 1st, 2021. I certainly hope so. And all the extracurricular and co-curricular positions will return to normal by then, but instead it really was the suggestion by main PERS to maintain plan compliance. I will do my best to answer any questions you have. I hope Kathy Moore from main PERS will be here to testify today, and she has a wealth of knowledge and expertise on this matter. Thank you so much for your time and your attention and your service to the people of Maine.
Thank you, sir. I do see a question from Representative Bradstreet.
Thank you, Mr. Chair. Thank you, Mr. Kaczynski. And I apologize. My reception is not real good here, and I missed part of what you said.
You want me to reread my whole testimony, sir?
No, that won't be necessary. Thank you very much. And perhaps someone coming after you can explain how the credit would be purchased. But I'm wondering, is this designed for people who have maybe been involved with co-curricular or extracurricular activities throughout most of their careers, or just the last 3 years? Is there any differentiation there in the bill?
That's a great question, sir. I would say it's really only the final 3 years, because the final 3 years is what's going to impact their retirement earnings for the rest of their lives. So we have had plenty of examples, and hopefully you have some testimony from some teachers on this, who they may have been the drama club leader for 15 years, and now they're ready to retire, but that drama club didn't meet last year, and they're probably not meeting this year. And if that person retires at the end of this school year, that's going to adversely impact their retirement earnings for the rest of their lives. So it's really kind of both. And keep in mind as well, I should have included this in my testimony. If you were the drama club director all those years, you were paying your 7.65% on that stipend, just to be clear. So you have paid that your percentage, and the employer has paid its percentage towards those stipends. But now when you're going to retire because of COVID, that might be a few $1,000s less that you're gonna be able to count towards your retirement benefits because these stipended positions were cut. And the purpose is to allow people to buy back that credit. So I hope there's no fiscal impact to the state. That was our hope. But we have had a number of places where, because the stipends were cut, it's had an adverse impact on their retirement earnings if they choose to retire over the next 3 years.
Thanks.
Representative Gear, then Representative Cuddy, please. You're muted, Representative.
I can't see her either.
For me, she's just above you, John. We'll go to Representative Cuddy and come back to Representative Gear.
Thank you very much, Senator Rafferty. Thank you, Mr. Kaczynski. And looking at the amendment to the bill, the amendment is not striking and replacing, correct? It is amending the original bill. Okay.
Correct. As I said in my testimony, the current version of the bill only deals with service credit, and that really only impacts your non-full-time school employee. You can't buy, if you're a full-time school employee, you can't buy service credit above the 1 year. And Kathy Moore or me personally will do a better job of explaining that perhaps. But that was the draft of the bill before you only really deals with the service credit. So it really only impacts those non-full-time educators who maybe have a stipend and want to use that to help increase their service credit. The amendment would be in addition to the bill before you, which would allow an individual to buy back they would be able to basically impute the income of a stipend that may have been lost due to COVID, so that it did not negatively impact their final 3 years.
Follow-up, Senator?
Yes.
So did you work with MEPers on the amendment?
Yes.
Okay, then I'll save my questions for MEPers then.
As you know, MEPers is always neither for nor against on bills, but yes, we did share with them the concerns and spoke with them a couple times, and they were extremely helpful as always.
Representative Gear,
Can you hear me now?
we can.
Oh, good. Sorry about that. Thank you, Mr. Chair. And thanks for being here, Mr. Kaczynski. I just want to make sure I'm hearing clearly. This will cover through July 2022, right? I might have misheard. I thought you said 2021, and I said, gosh, we're definitely not going to be done with this thing on 2021. So it would cover lost compensation through July 2022, correct?
No, in my testimony, I referenced just through July 1st, 2021. We would prefer it go through July 1st, 2022, but MEPers had said to us, due to plan compliance requirements, we can't, that would be ill-advised. And so if this continues on and we see stipends again canceled next fall, they would advise that we come back with another bill to address it. Because of certain IRS plan compliance concerns, they wouldn't want us to say going forward in the next school year, it could be imputed income for the purposes of your pension. But at least if we say July 1st, 2021, it will be confined to the pandemic, and we'll have to reevaluate in the fall whether or not we need to do this again or ask you all to do this again.
Great. Thanks for clarifying that.
Any other questions of Mr. Kaczynski? Is there an indication as to, I'm just curious, the number of schools that paid stipends continue to pay versus those that did not? Do you have any evidence to that matter?
Senator, that's a great question. I would say it was all over the place, and depending on the type of stipend. So we saw a lot of athletic stipends cut. They may have kept the department chair stipend if that was in a school. Each school deals with stipends differently. So you may have had your department chair stipends, unlikely to have the drama club stipend. But again, the way the pandemic hit last March, they may have paid the drama club stipend in January, and then by March hit. So I don't have the answer, but I would assume, sir, that it's pretty all over the place in terms of how schools reacted to the pandemic and how they addressed it.
Sure. And Representative Pebworth, please.
Thank you, Mr. Chair. And thank you, Mr. Kaczynski, for being here again. I, as a former teacher, I took a little offense in not what I heard from your testimony, but comments and before that suggests that as a teacher, if I'm about to retire, I want to bulk that up. Therefore, I'm going to ask to take on some of these stipended opportunities. Is that something that's running rampant? Or in fact, is this acknowledging teachers who are in leadership position, who have been being the drama club for years and years? If you could say a little bit more about that, that would be helpful. Thank you.
Absolutely. I would just say, and I thank you, Representative Pebworth. I would agree. I hope nothing in my testimony gave anyone the impression that people were trying to rig the system here. But I would say very clearly that that there's a lot of protections already in place to prevent that from happening. So even that to Representative Gear's point, that's one of the reasons we had to say July 1st, 2021. That's one of those protections to make sure people are not using some mechanism to ramp up their salaries. But the people that I know who have come to us and asked us to, to work with Representative Dodge on this bill, these are people who have done these for decades. And it's important to note too, stipends are often managed and controlled entirely by the school district. So it's the school who decides, oh yeah, you should be the department chair again, or hey, you should be the football coach again, or yeah, you should run the drama club again. So it's really controlled by administration and by our schools in a lot of cases. So I don't see anything nefarious here, and I don't see anyone trying to do anything nefarious. And again, even if they take those stipended positions, they will pay the 7.65% on that earning.
Thank you very much.
Thank you.
Any other questions? Seeing none. Thank you both very much for being here, and I think that we'll probably have some more questions for Mr. Bailey and Ms. Moran, I believe. Thank you. Alyssa, is it Mr. Bailey next?
Yes.
Thank you. Good morning, Mr. Bailey.
Good morning, Senator Rafferty. And I don't see Representative Sylvester here, but good morning to all the members of the Labor and Housing Committee. Pleased to be here today. I'm Stephen Bailey, and I'm the Executive Director of the Maine School Boards Association, testifying today on behalf of the Legislative Committee of the Maine School Boards Association in support of LD 509. We do see this as a positive bill, a good bill. And I would add, in terms of listening to Mr. Kaczynski and the proposed amendment, that we would be in favor of that as well. School boards support this legislation because it allows a teacher whose extracurricular activities help them earn service credit toward their retirement if those activities, like coaching certain sports, were interrupted by COVID. And we understand also that this would be inclusive of the educational support professionals, EdTech 2s and EdTech 3s, who also are a part of the Maine PERS retirement system. And many of those folks are very important in being able to provide co-curricular activities for our students, and they are ones who take advantage and are very positive in providing those opportunities for our students and our schools. We know that this bill intentionally limits the time period for this opportunity to COVID-related restrictions. In hearing the 2021 date, we understand why that is important as well, and we'll hear more from Kathy Moran about that. We also know it'll affect staff differently depending upon the district where they work. Not all sports teams, for example, were completely shut down. And we do know that some stipends were paid last year, or partial stipends were paid based on the amount of work that individuals did with those teams as they were involved in the COVID shutdown last spring. It did change, however, the scope of their activity and limited it some in cases to regular team workouts rather than competitive play. Our understanding is that this would not affect school district finances since the employee would be purchasing service credits as well as their stipend, and the transaction would be between the teacher and their retirement system. So also there would be no increased fiscal note for the state. So with it not affecting the districts and not affecting the state, and it being the choice of the individuals, this would be certainly a win-win for all parties involved. Certainly be glad to take any questions if I can help.
Oh, sorry. I think I had myself muted. I see, I think this is an old hand, but I'm not sure. Representative Gear? You caught, thought I caught you. Just for clarification, Mr. Bailey, if I were buying back this, would that have to be completed by July 1st, also the buyback itself?
That I am not sure. That would be a great question for Kathy Moran in terms of time period when that would have to be done. Obviously it's going to be different for different individuals in terms of the amount that they would have to purchase.
Thank you very much. Any other questions for Mr. Bailey? Sir, again, we thank you for your time, your testimony, and your expertise. You have a great afternoon. Thanks
You as
for
well.
being here.
Great to see you all.
I believe Ms. Moran of Maine PERS will be here. Representative Sylvester with a question. Oh,
Just letting you know I'm back, sir, and happy to take over the timing again. Sorry to have to jump out of committee so quickly.
that's okay. And actually looking at my screen, Ms. Moran, if you would excuse me for a moment. Representative Morris, good morning, sir. I'd just like to give you an opportunity to say hello. Sorry about that.
No worries. Thank you, Mr. Chairman. I'm State Representative Joshua Morris. I represent the towns of Turner, Leeds, and Livermore, House District 75. Thank you.
Thank you, sir. Good morning, Ms. Moran.
Good morning.
You have the floor. Thank you for being here.
Thank you. Senator Rafferty, Representative Sylvester, and members of the Joint Standing Committee on Labor and Housing. My name is Kathy Moran, and I'm the Manager of Actuarial and Legislative Affairs for the Maine Public Employees Retirement System. Maine PERS is neither for nor against LD 509. We're here to provide information and offer any assistance the committee might need regarding this bill. Under current plan provisions, teachers who perform extracurricular or co-curricular duties are able to include wages from those duties as earnable compensations toward their benefit calculation. Service credit earned by a teacher member is limited to 1 full year of service credit for each school year. Therefore, for most full-time teachers, performing extra duties does not result in an increased service credit total, but can result in a higher average final compensation used to calculate benefits if the duties are performed in the member's highest 3 years of earnings. For teachers who are less than full-time, performing extra duties may also result in additional service credit, again with 1 year of service maximum permitted per school year. LD 509, as drafted, would permit certain teachers who have been impacted by the unavailability of those extra positions during the pandemic to elect to pay the cost to include any lost service credit toward their benefit calculation. We understand that an amendment to the bill will be proposed, and I believe you have that before you, that will also allow for the inclusion of lost wages. Taken together, the bill and amendment address the earnable compensation and service credit impacts of the loss of the ability to include performing additional duties toward retirement benefits. The bill as drafted will not have a fiscal impact on the plan since it requires the member to pay the full actuarial cost of the purchase. We would note that the individual circumstances may impact a member's ability to take advantage of this purchase opportunity because of IRS contribution limits. This is more likely to be the case for a member who is already making additional contributions toward the purchase of other service credit. We do not anticipate that many of those impacted by LD 509 would reach those limits, but we did want to mention that. Thank you for your consideration of this testimony. I'd be happy to answer any questions and will be available at your work session.
Thank you very much. Representative Drinkwater, followed by Representatives Cuddy and Bradstreet.
Thank you, Mr. Chair. Thank you, Kathy. You are getting to be a real professional when it comes to these Zoom meetings, may I add.
Thank you.
And a little shout out over there to my fellow seatmate on education, Representative Dodge. It's nice to see you, and you always brighten up the day with your glasses. This bill is saying that it won't have a fiscal impact. Can you help me understand the contribution rates? I understand when it comes to retirement, the employee pays 7.65%. What does the employer have to pay?
I can get you that current rate. The normal costs for the teachers is around 4%, but I'll get you the specific information. And then the state for teachers pays the unfunded liability costs. So there's an additional percentage associated with that, but I'll get you that information.
So my real question is, when it comes to no fiscal impact on local communities, will the local communities and their school budget have to participate to help buy back what they lost?
The way this bill is drafted, the answer is no. This bill requires the teacher to pay the full actuarial cost of buying that additional time or imputed income, which means that the teacher themselves pay the cost for the inclusion of that additional service or money.
So they would have to pay their share plus the employer's share?
In essence, they would pay actuarial costs basically means funding the benefit that you're going to get out of the additional time or money. So it keeps the plan whole in terms of the additional benefits that will be paid for that service or income.
Certainly. I guess I would be curious to see what the percentage the employer has to pay for the work session. So thank you very much.
Sure.
Representative Cuddy, please.
Thank you, Senator. Thank you, Ms. Moran, for being here. Your information is always fantastic. So am I correct in phrasing it this way? When we as a legislature make a prospective change to a retirement plan, we have to fully fund the actuarial cost of that difference going forward. Is what's happening with this bill that a teacher is funding, the employee is funding the actuarial cost of that going forward?
They're paying the actuarial cost of the added benefit that they will receive for the inclusion of the additional service credit and or income.
Okay, so a teacher has lost out on whatever the income may have been, or the part-time employee, whatever, they've lost out on that income because COVID-19 happened, and drama club is the example we're using. Drama club doesn't happen, so they've lost out on a couple of $1,000s in pocket there. In order to not lose out on that money in the retirement, they're going to take money out of their pocket and pay it to main PERS in order to maintain the retirement benefit they would have gotten if they were able to be the drama coach for that year.
That's correct. That's how this bill is drafted.
Right. I mean, it's the only solution we have available to us, but it's just one of those things where teachers who are already, in my view, not being paid well enough for what they're doing. As Mr. Kaczynski said, they put in much more work than the stipends are really worth. And this isn't a question for you. And I'm not supposed to soapbox, so I'm going to stop soapboxing. And I apologize to the committee for that, but it's just frustrating.
Thank you, sir. Any other questions of Ms. Moran, please? None. Well, seeing none, again, thank you very much for your testimony and your expertise. We appreciate your help. Have a great afternoon.
Thank you.
I believe, Alyssa, that was it in terms of testimony.
Yes, that's true.
Representative Dodge, thank you very much for being here. Have a great day. Well, I am going to call the hearing relative to LD 509 to a close. And at this time, I would like to, let's see, making sure I've got the right order here. Next up will be LD 567. I'll open that hearing. And LD, sorry, 567 is an act to amend the penalty for early retirement for certain members of the Maine Public Employees Retirement System. And is, I believe, I have this right, Alyssa, and our first testimony will be from...
We have the sponsor, Rep. Hanley, here.
Oh, we do? Outstanding. I wasn't aware of that. Thank you, Representative Hanley. How are you this morning?
I'm fine. How are you?
We're doing well. Thank you. And we're going to give you the floor, sir.
Okay, thank you very much. Glad to be here. You've had a busy morning, so I'll be as brief as I can. Good morning, Senator Rafferty, Representative Sylvester, members of the Joint Committee on Labor and Housing. I'm State Representative Jeff Hanley, representing House District 87, which are the towns of Pittston, Alma, Westcasset, and Randolph. I'm here today to introduce LD 567, an act to amend the penalty for early retirement for certain members of the Public Employees Retirement System. This bill was reported out by this committee last session and died between chambers in the Senate when we ended the session early. This legislation seeks to remove a penalty that affects a group of state employees that chose to retire in a very narrow window of time. And I cannot explain why the penalty changed from 2.25% to 6%. Maybe others can help answer that question later, but I mean, it's a penalty for each year you retire early. You lose that amount, a percentage of your income, your retirement income. I also cannot explain why there are two small windows, July 2011 to January 2012, and for teachers only a window of July 2011 to July of 2012. Again, maybe someone listening can answer that question as well. It seems odd that we have trapped a group of people in a small segment of time. The intent of this bill is to impose the same penalty rate across all state employees that choose to retire before age 62. And the bill is only looking forward to change the rate of future payments to our retirees. In other words, there's no retroactive component to it. I know there will be a cost to put this fix in the budget. However, out of a state of justice, this is the right thing to do. Keeping in mind that all the money flowing to our retirees will be spent right here in the state of Maine, which can only help our overall economy. I ask you to vote or not to pass on LD 567, and I will try to answer any of your questions.
Thank you, Representative Hanley. Do we have any questions for the representative? Sir, I'm not seeing any at this time. So again, thank you very much for your testimony.
Thank you very much.
Yes. Have a great day.
You too, sir. All of you have a great day.
We have up next, is it Mr. Kaczynski? Am I still good here? Alyssa? Oh, there we go. Oh. Did I lose you, Alyssa?
So I apologize. A member of the public called me asking about testifying on 575.
Oh.
So I had my headset off. Could you repeat what you said? Thank you.
No, we're good. I was just looking for our next testimony, and it is he is alive and well and living in front of me right now. Mr. Kaczynski.
Perfect.
Welcome back.
Thank you so much, Senator Rafferty, Representative Sylvester, and other esteemed members of the Committee on Labor and Housing. My name is John Kaczynski. I'm here on behalf of the Maine Education Association, which represents 24,000 teachers, educational support professionals, and retired educators across Maine, and we're here to support LD 567. For teachers and state employees, the cuts to the pension system pushed by former Governor LePage in the legislature in 2011 have been devastating to current and future retirees. And as you know, any broad fixes to repair the damage that was done has eluded us due to Maine's constitutional restraints on making improvements to our pension system without paying the cost of those improvements up front. I've spoken about these devastating changes pushed by our former governor before this committee, so I will not use my time today to drone on about the cuts to the cost of living increases for current and future retirees and the devastating impact these cuts will have for decades to come. I will not go on and on and on about the changes made in the retirement age, now requiring some teachers and state employees to work until they are 65 to avoid penalties in their pension. And I will not take your time today to go into detail about how these cuts to the pensions were passed to reduce income taxes for the top. Today, instead, I'd like to focus on one specific element of the bill before you that intends to provide minor relief to the teachers and state employees who retired to maintain health care coverage in retirement. Yet another part of the cuts passed in 2011 were changes made requiring retirees to be normal retirement age to qualify for health insurance, thus meaning a person had to be 60 or 62, depending on when they started, to receive the state contribution for health care. Prior to 2011, a teacher and state employee could receive the state contribution for health insurance if they had 24 years of service. But after these cuts in 2011, they had to retire by July 1st, 2012 for teachers and ed techs, 2s and 3s, to qualify for the state health insurance contribution if they were not normal retirement age. And as you heard the sponsors say, for state employees, they only had until January 1st, 2012 to receive the state contribution for health insurance. Given the concerns about this change from some teachers and state employees, especially those with underlying health conditions who were concerned about working until normal retirement age, some decided to take the penalty, preserve their ability to access the state contribution for their health care. In other words, they retired preemptively to maintain their health insurance contribution. I included in my testimony some remarks about another bill, 293, and another bill that's coming from Representative Billy Bob Falkingham regarding the health insurance. I'm not going to talk about that here, but just to reiterate, that's part of the reason this is so important, is given the cuts that we've seen and given the ability to fix some of these changes that were passed in 2011, things like those health insurance pieces are very critical. Put simply, this bill will not make current or future retirees whole, not even close, but it does show a bit of remorse for the harmful decisions of our previous governor and legislature. It attempts to restore a modest amount of what was cut from vested employees dedicated and hardworking public service. Thank you for your time, your service to the people of the state of Maine, including our retired educators and state employees.
Thank you, Mr. Kaczynski. Do we have any questions? Representative Gear.
Thank you, Mr. Chair. Can you hear me?
Sure can.
Yes.
Great. Mr. Kaczynski, thanks again for being here. I am just trying to put my mind back in time here with you. So this is to remedy changes that were put in 2011, and those changes could you just describe the specific effect those changes had? And was this just put in for teachers, or was this for all state employees?
Oh, thank you for your question, Representative Gear. And I'm sorry if I was a bit flippant in my testimony about that, but I would say in 2011, there was a wholesale attack on the pension system. And so there were a number of changes that were made during that time. The cost of living for current retirees was frozen for several years, so they got no increase in their pension. The retirement age for those less than 5 years of service was lifted to 65. It had previously been 62. Before that, it had been 60. So now if you're a teacher with less than 5 years of service as of 2011, you're expected to work to 65 to retire without penalty. And one of the changes that this bill, I think, attempts to address is something very specific, which is prior to 2011, if you had 25 years of service, you qualified for the state contribution for health insurance. And I should say, Representative Gear, these cuts that were enacted in 2011 applied to all MEPERS participants in the teacher and state employee plan. There's other things called the PLDs that you might be hearing about, participating local districts. I don't know to the extent it applied to them, but it applied to the teacher and state plan. So the change I think this bill is attempting to address is the teachers were given, and state employees, a window to retire in order to maintain the state and health, the state contribution for their health insurance. At that time, and still today, the state pays 45% of the cost of the health insurance for retired educators. There's a bill before you to lift that to 55%. It's been stuck at 45% since 2008. The Education Committee passed that bill 12-1. maybe 2 weeks ago. So it might even be on your calendar when the legislature convenes this week. But the specific element here is the cut. There were many, many, many cuts that were made to the pension system in 2011. I believe it was purposeful. I believe the constitutional amendment is clear, knowing it would be hard to fix any of those changes that were made. In this one in particular, we saw more people retire in order to maintain their state health insurance contribution, because that was one of the changes they made in 2011. So they were willing to take the penalty that this bill attempts to fix or reduce in order to maintain health insurance. And it's most important to remember as well, there are plenty of teachers who do not qualify for Medicare. They never will qualify for Medicare. So the state contribution to their health insurance is the only health insurance they can count on in retirement. I hope I answered your question, Representative Gear.
Thank you. Yep.
Sorry, Representative Bradstreet, please.
Well, thank you, Mr. Chair, Mr. Kaczynski. Having not been around back in 2011, can you give me some state of what the retirement system was like back then? And if something was done to correct it, what else could have been done back in 2011?
That's a great question, sir. And I don't know if there was a problem to be solved, because the constitutional amendment was passed by voters, I believe, in 1996. And the constitutional amendment required the state to pay the full cost of the pension each year. Prior to 1996, the state had been kicking the can down the road and not paying its obligations to the pension, which created a ballooning problem. But the legislature and the voters in 1996, I believe it was 96, took responsibility for that. And if you look at the Constitution, it created those protections. And that's the reason our pension system remains among the best funded and the most fiscally solvent in the entire country. I think what was driving the concern in 2011 was a desire to reduce income taxes for the top. It was a desire by the previous administration to reduce that top income tax rate. And so there were millions and millions and millions of dollars of pension cuts that were enacted on teachers and state employees in order to reduce the top income tax rates in our tax code. I hope that answers your question, Representative Bradstreet.
Yes, thank you. It's always good to get a different perspectives on what's happening. So I appreciate that.
Absolutely. Oh, you're on mute, Senator Rafferty.
Thank you. Representative Gear, did you have an additional question? No?
No, sorry. I just forget
Okay.
my hand every time.
Any other questions, please, of Mr. Kaczynski? Seeing none at this time, sir. Thank you very much again for your testimony and your expertise.
Thank you.
Always happy to have you with us. Thank you. Next up, is it Ms. Pinkham?
It looks like Miss Pinkham is left. And we have no opponents and one neither for nor against, which would be Kathy Moran again.
And that would be Ms. Moran. Thank you very much.
Mhm.
Good morning again, Ms. Moran.
Good. Oh, I guess it's good afternoon, almost. Senator,
Well,
we're getting there.
You are correct, yes.
Senator Rafferty, Representative Sylvester, members of the Joint Standing Committee on Labor and Housing. My name is Kathy Moran. I'm the Manager of Actuarial and Legislative Affairs for the Maine Public Employees Retirement System. Maine PERS is neither for nor against LD 567. As is typical, we're here to provide information and offer any assistance the committee might need regarding this bill. Maine PERS administers state-sponsored defined benefit plans, including those for state employees and teachers. The majority of state employees and all teacher members are covered by the regular plan, which requires 25 years of service and/or attainment of normal retirement age of 60, 62, or 65. A member who reaches 25 years of service prior to reaching normal retirement age may retire with a reduction, 6% for most current state employees and teachers for each year below normal retirement age. The reduction reflects that benefits will be paid to the retiree over a longer period of time. In essence, lower benefits paid over a longer period of time equate to a higher unreduced benefit being paid over a fewer number of years. LD 567 would permit certain state employees who retired between July 1st, 2011 and January 1st, 2012, and teachers who retired between July 1st, 2011 and July 1st, 2012, to have their benefits recalculated based on an early retirement reduction of 2.25% per year rather than the 6% reduction. This recalculation in the bill would be effective October 1st of 2021. LD 567 will have a fiscal impact because the Constitution does not allow the creation of new or additional benefits unless immediately and fully funded. New benefits are created under LD 567 because retirees would be receiving benefits higher than currently accounted for and funded, creating a new unfunded actuarial liability. During the 129th legislature, the committee considered LD 1184, which included the same proposal as you've seen in LD 567. At that time, Maine PERS identified approximately 115 retirees who would be impacted by the proposal and estimated the cost for the plan change to be approximately $5.8 million for a prospective recalculation of benefits for that group. If you move forward with this bill, we'll work with our actuary to update these costs for LD 567. Thank you for your consideration of this testimony. I'd be happy to answer any questions and will be available for your work session.
Thank you very much. I have a question from Representative Pebworth, please.
Thank you, Mr. Chair. Thank you, Ms. Moran. I am in need of Maine PERS Retirement System 101. And I know you've spoken with us before, but I am asking, and perhaps I'm the only one, I seem to need a visual of this, and I seem to need more information in my hands to understand this fully. Can you provide me with that?
Well, can we provide you with a visual, or can I provide you with Maine PERS 101?
I'll settle for the one-on-one around this issue in particular.
Okay. So I think the people who spoke before me did a good job of capturing the essence of what this issue is. I mean, people who, there have been a series of plan changes over the years that have impacted various groups of our members to change their retirement age, for example, from 66 to 62 or to 65, to change the early retirement reduction, for example, from 2.25% to 6%, which that change actually happened back in 1993. So we have these, what we call tiers of members who have different retirement ages and different reductions in benefits. Excuse me, the situation addressed in this bill, sorry, I think John Kozinski did a good job of explaining the health insurance aspect of this bill. I mean, there were a group of retirees in those windows that are being proposed in this bill. Those individuals, as we understand it, made elections to retire during that period, in essence, to maintain their health insurance. I believe that's what John Kozinski was speaking to, and I think others may have spoken to that also. That there was this window of opportunity whereby those who had been working for whatever number of years and are eligible to retire, if they were to continue employment beyond the dates that would then set, I believe they were in the budget, then they would then become responsible for payment of their health insurance if they didn't retire within these windows. And as you can expect, that's a significant cost to members, retirees, the health insurance portion of it. Many state employees, for example, when they retire, they receive their health insurance at no cost to themselves. So to go from having fully paid health insurance into retirement to having to pay that cost until normal retirement age is obviously a significant change for people. So there were those who, during this proposal, during this change, who were eligible to retire, who had to make a decision to either take a reduced benefit on the pension side to keep health insurance, or to keep working for example, until normal retirement age in order to, again, have that paid health insurance. So the people in the group that we're talking about are people who obviously made the decision to retire, to start collecting their pension, and were able to maintain their health insurance. I'm not sure how much more would be helpful for you. I want to make sure I'm giving you what you need for information.
That is very helpful. And I think I can follow up with specific questions on my own time. Thank you.
Okay.
Thank you. Representative Drinkwater, please.
Thank you, sir. Nice to see you again, Kathy. You're doing a great job.
Thank you.
Listen, for historical purposes, the state of Maine was unable to meet their obligations back in 2010, 2011. And aren't they continuing to make payments to get caught up?
So the constitutional amendment, of course, deals with the unfunded liability as established back in 1995, 1996. So that's dealing with that liability. I think what you're referring to is, during 2008, 2009, there were significant market losses. And so those changes, of course, when you have market losses, that changes the pension costs for the plan. And losses to the plan are amortized over now 20 years. So to the extent there are still market losses from that period, then you're correct that the state is continuing to pay for those based on the current amortization of that unfunded liability.
Yes, because I remember in education that we discussed it last year. So thank you for clarification on that.
You're welcome.
Any other questions of Ms. Moran? Ms. Moran, thank you very much for being here today again. And always appreciate your expertise and your availability.
Thank you.
Have a great afternoon.
You too.
And we have made that transition. Any other questions relative to LD 567? Seeing none, I'm going to bring that hearing on LD 567 to a close. That in essence brings our morning session to a close. And I have 12:08, and I believe we have a public hearing. I'm sorry, no, a work session this afternoon. And I lost my paperwork here. I have everything organized until I get started. Are we to reconvene at 1 o'clock? Is that correct?
Yes, that's correct.
Oh, thank you. So, so we will be reconvening at 1 with our work session, but in the meantime, I'll pose this question that if it's possible, Alyssa, you have to tell me, can we be put into our caucus groups? And within that, we'll make our own decisions as to relative grabbing lunch or doing a little bit of a work conversation before that work session.
Yeah, I can put you guys into your caucuses. I'm sending you the invite right now.
Thank you all, and we'll see you at 1.